When divorce decrees outlive the divorced. A divorce decree is not a suggestion. It is not a handshake. It is not a rough outline of what the parties might do later if everyone feels cooperative. It is a court order. That is the central lesson of Alleman versus Slaughter, a recent Utah Court of Appeals decision involving divorce, death, joint tenancy, unpaid equalization money, and a house that became the center of a legal fight after one former spouse died. Here's the basic story. April Slaughter and John Alleman divorced. Their decree awarded the marital residence to Alleman. To equalize the division of the marital estate value, Alleman was ordered to pay Slaughter $200,000. Once she received the money, Slaughter was supposed to quit-claim the house to him. Before that happened, Alleman died. His father, acting as special administrator of the decedent's estate, tendered the $200,000 to Slaughter. She refused to accept it and refused to sign over the house. Her argument was that the house had been held in joint tenancy with right of survivorship. So she argued when Alleman died, his interest passed to her automatically. The district court agreed with her. The Utah Court of Appeals did not. The Court of Appeals held that the divorce decree remained enforceable after Alleman's death. That matters. Once a decree of divorce resolves marital property rights, those rights do not vanish because one former spouse dies before every document is signed. The estate may still have to perform the deceased spouse's obligations, and the surviving former spouse may still have to perform hers. This case also illustrates why joint tenancy is not a trump card after divorce. Ordinarily, when one joint tenant dies, the surviving joint tenant receives the deceased person's interest automatically. But divorce changes that. Utah law generally severs joint tenancy interests between former spouses at divorce unless the decree or governing instrument clearly says otherwise. The decree in this case did not say the joint tenancy survived, so the survivorship argument failed. In plain English, the surviving former spouse could not use pre-divorce title paperwork to defeat the post-divorce decree. The case also teaches a drafting lesson. If payment is supposed to be a strict condition before property changes hands, say so. If a party keeps a lien until payment is made, say so. If failure to pay by a deadline changes ownership, say so. Do not assume a judge will later insert missing language. For the public, the warning is simple. Do not assume divorce is finished just because the decree is signed. The decree may be final, but follow-through still matters. Deeds must be signed. Equalization payments must be made. Titles must be transferred. Beneficiary designations must be changed. Loose ends can become expensive when life takes an unexpected turn. The lesson is not complicated. When the decree divides the property, the decree controls. And when the decree is poorly drafted or when the follow-up documents are ignored, the fight may not be over at all.